We're going to spend a lot of time with the Constitution this semester and one amendment specifically, but let's take a look at some of the others and see how they might be affecting our understanding of media law. So let's consider the Constitution itself for a second and where it came from. It was created in 1787 in Philadelphia by the Constitutional Congress, which gathered there in the summer of 1787 to do basically a follow-up to the Declaration of Independence, which was a terrific document, but it didn't show us how to shape the government. And so the Founding Fathers spent the entire summer really looking at every aspect of government that we would need to have a successful framework, and it's been pretty successful because we've had it for more than 200 years. Among the key things they developed here were the three branches that we know so well, which would be the executive branch of the presidency, the legislative branch of Congress, and the judicial branch, which of course is the Supreme Court. Now, at the same time that they did this, they also crafted amendments to the Constitution, the first 10. And what they called this was the Bill of Rights. These were things that were inalienable for all people who resided in the United States. Of course, you know, there were some restrictions as to who those people were at this time. But the idea being that we had certain inalienable rights that needed to be written out so that we guaranteed them. So this is pretty much what the Bill of Rights kind of sums up on the key topics, and you're welcome to check out more of these. We're going to focus on a few of them that really relate specifically to journalism. You know, some of them are familiar to you. The right to bear arms, big debate, quartering soldiers is number 3. You have the right not to incriminate yourself, and number 5. You'll notice 6th, 7th, and 8th deal specifically with being arrested and what it's like going through the court system. That's certainly specific to that time, was a very important topic. Number 9, I'm not sure if you knew actually, is that no other amendment can supersede the other amendment, so you can't cancel one out with one. And this idea of that the powers that the federal government has, that if they don't stipulate something specifically, then the state still retains those rights. So let's take a look at some of these a little bit more specifically, because these are our journalistic favorites. First Amendment, of course, is our most favorite of all, and we're going to talk quite a bit about that one. But let's look at another one that's a favorite of ours, and this would be the Fourth Amendment. And the Fourth Amendment says that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. No warrant shall be issued but upon probable cause, supported by oath or affirmation, particularly to describe the place to be searched and the persons or things to be seized. Now, this is something that's weighed when we're dealing with police coverage. We'll often have to balance someone's right to be, again, secure in their person, house, paper, in terms of whether or not we get access. This is where a lot of privacy restrictions come in as it relates to journalistic law. Now, another one that comes into play for us is the Sixth Amendment. And the Sixth Amendment says that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crimes have been committed, etc., that they have compulsory process for obtaining witnesses in his favor and have the assistance of counsel. So this is where you're guaranteed to have a lawyer. This is where we get some restrictions about covering court cases. So we may get some prior restraint issues that come up in relation to the Sixth Amendment. We'll take a look at how that comes up. Now, a couple other ones that are important to us would be, let's take a look first at this one. This is the 10th Amendment. So this says basically that the powers that are not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people. So just because something's not outlined in the Constitution or by the federal government doesn't mean you don't have that right, and so that may come into play. And then one that is not part of the Bill of Rights because it wasn't part of the first 10, but is actually the 14th Amendment, is something you may have heard about. And this is that all people born and naturalized in the United States and subject to the jurisdiction are citizens, and the state shall not make or enforce any laws which shall abridge the privileges or immunities of citizens of the United States. And this is the one that really gets into kind of a catch-all phrase for us, in terms of the state won't deprive anyone of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. So a lot of times we're going to balance the First Amendment and the 14th Amendment when it comes to getting some of our stories.